Hello everyone. Welcome back to our channel U.S. Immigration. We hope you're doing great. In this video, we will talk about the appeals court ruling disappoints on Biden's parole program. In recent months, a series of legal disputes have intensified as Republican-led states challenge the Biden administration's immigration relief programs. Central to these battles is the question of whether these states can prove that federal policies, such as the Keeping Families Together initiative, impose genuine financial harm. These disputes are not only shaping the future of immigration relief but also highlighting broader issues of federal versus state authority in immigration matters. As the legal landscape evolves, understanding the complexities of these challenges is crucial for grasping the ongoing debates surrounding U.S. immigration policy. If you are interested in this, so to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So without any further delay, let's jump into the video. States argue financial harm from immigrant relief programs, legal battles over standing and harm. As Republican-led states challenge the Biden administration's immigration relief initiatives, they face a significant hurdle proving they have been harmed by these programs. One notable program under scrutiny is the Keeping Families Together initiative, which offers immigration relief to spouses of U.S. citizens, including employment authorization and a pathway to permanent residency for those who have lived in the U.S. for at least a decade. The Biden administration has leveraged its parole powers to admit immigrants on an unprecedented scale. This use of parole has triggered a series of legal battles, with conservative states arguing that these policies impose financial burdens on their economies. Last month, these states achieved a temporary freeze on the new parole-in-place program. However, to overturn the program, these states must first demonstrate they have standing to bring the challenge, meaning they must show concrete harm from the policy. Legal experts suggest that recent Supreme Court decisions could complicate these efforts. States challenging these programs must not only prove that they face financial harm, but also that the harm is directly attributable to the federal policies in question. Karen Tumlin, an attorney with the Justice Action Center, notes that recent Supreme Court rulings have made it clear that states must provide substantial evidence of injury, not merely speculative claims. For instance, GOP-led states previously attempted to block another parole program, which allowed up to 30,000 migrants monthly from countries such as Cuba, Haiti, Nicaragua, and Venezuela. They argued that this program would increase their expenditures on healthcare, education, and other public services. However, a district court dismissed this challenge, noting that the number of new migrants had decreased since the program's implementation, thereby reducing the state's financial burdens. This issue is now being appealed to the U.S. Court of Appeals for the Fifth Circuit, with the Biden administration arguing that the states cannot demonstrate actual harm. The outcome of this appeal will be critical in determining whether states have met the standing requirements necessary to challenge the parole programs effectively. Immigrant advocates assert that recent Supreme Court decisions support their position. In prior cases, the court ruled that Texas lacked standing to challenge provisions of the Indian Child Welfare Act and Department of Homeland Security enforcement priorities, emphasizing that states must show tangible harm rather than hypothetical or speculative damage. Despite these precedents, proponents of the GOP challenges argue that such rulings might not fully apply to the current parole policies, which they claim directly affect employment opportunities for American workers. Legal challenges to these immigration relief programs will ultimately depend on how courts assess the actual versus alleged financial impact on states. As these legal battles unfold, the key question remains whether the states can substantiate their claims of harm to meet the standing requirements necessary to challenge federal immigration policies. Texas court to delay transfers of cases out of Fifth Circuit. New local rule takes effect in September in Northern District of Texas. Starting September 3rd, a new local rule will be implemented in the Northern District of Texas Federal Trial Court that affects the transfer of civil cases outside the jurisdiction of the Fifth Circuit Court of Appeals. According to the newly posted rule on the district court's website, any order transferring a civil case to a district court outside the Fifth Circuit will be stayed for 21 days. This stay period is designed to allow time for affected parties to agree on the transfer or address any objections. The court is open to receiving comments on this rule until August 19th. The implementation of this rule follows heightened scrutiny and criticism directed at the Northern District of Texas, particularly regarding the practice of judge shopping. This practice involves conservative litigants filing lawsuits in this district with the hope of securing a favorable ruling from a court perceived as more sympathetic to their positions. Despite federal judiciary guidance urging judges to curb such practices, the Northern District has yet to adopt a specific rule against it. The introduction of the new rule aligns with recent developments involving the Fifth Circuit's review of case transfers. For instance, the Fifth Circuit recently reversed a decision involving a challenge to the Consumer Financial Protection Bureau's credit card late fee cap. Initially, this case was ordered to be transferred to a federal trial court in Washington by U.S. District Judge Mark Pittman of the Northern District of Texas. However, the Fifth Circuit intervened, staying the transfer and blocking the rule from going into effect until further review. In another notable case, the Fifth Circuit considered a petition from SpaceX challenging the constitutionality of the National Labor Relations Board's actions. SpaceX had sought to have the case heard in South Texas, but a district judge transferred it to California. While the Fifth Circuit did not block this transfer, SpaceX subsequently filed a similar lawsuit in the Western District of Texas. The new local rule aims to provide a structured approach to managing case transfers and to address concerns about jurisdictional forum shopping, which has been a point of contention in recent judicial proceedings. States have ramped up efforts to enact stricter immigration laws, group fines. Efforts by state lawmakers to pass stricter immigration laws in the United States have surged notably over the past 4 years, especially under the Biden administration, according to a recent report by the League of United Latin American Citizens. The Civil Rights Group, which is the largest Latino civil rights organization in the country, highlighted that state legislatures have introduced 233 bills deemed anti-immigrant in the past year alone. This marks a significant increase from previous years -132 in 2023, 64 in 2022, 81 in 2021, and 51 in 2020. The proposed legislation includes various measures aimed at tightening immigration controls at the state level. These range from criminalizing unauthorized entry into the U.S. to restricting sanctuary policies that limit local cooperation with federal immigration authorities. Other proposals address non-citizen voting attempts, which, despite being a rare occurrence, have been highlighted in these bills. Additionally, some laws aim to crack down on the employment of undocumented workers. The report, which was initially shared with CBS News, underscores a growing trend among Republican state officials to challenge the federal government's long-standing authority over immigration and border policy. Notably, 97% of the proposed immigration measures since 2020 have been sponsored by Republican lawmakers. Texas has been a leader in this movement, with 91 proposed laws to enforce stricter immigration controls over the past 4 years. While many of these proposals have yet to become law, several states with Republican-led legislatures have successfully passed similar measures. For instance, late last year, Texas enacted SB 4, a groundbreaking law that authorized state officials to arrest, detain, and prosecute migrants suspected of illegal entry. It also allowed state judges to mandate the return of these individuals to Mexico instead of pursuing prosecution. However, a federal judge intervened at the Biden administration's request, blocking the law while Texas' appeal is under review. Following Texas' lead, other states such as Iowa, Louisiana, Kansas, and Oklahoma have implemented immigration laws similar to SB 4. These measures have also faced legal challenges from the Justice Department. Additionally, a ballot measure in Arizona, set for a vote in November, seeks to criminalize illegal crossings from Mexico outside legal entry points, a proposal spearheaded by state Republican lawmakers. In Florida, Governor Ron DeSantis signed one of the toughest state immigration laws in recent history last year. This law increased penalties for employers hiring unauthorized workers, invalidated out-of-state driver's licenses issued to undocumented immigrants, required state hospitals to collect immigration data on patients, and established new crimes for transporting individuals without legal status into the state. Republican state leaders argue that these stricter measures are a necessary response to record levels of illegal crossings at the southern U.S. border, which they attribute to what they view as overly lenient policies under President Biden. Texas Governor Greg Abbott criticized the federal administration for its perceived inaction, claiming that it forced Texas to independently address the immigration crisis. LULAC contends that these state measures are divisive and counterproductive. They argue that such laws could foster racial bias against Latinos, as many undocumented immigrants come from Latin America. Juan Proano, LULAC's CEO, criticized the approach of individual states, advocating instead for bipartisan congressional action to pass comprehensive immigration reform, which could provide clearer pathways to citizenship and more defined asylum processes. LULAC is currently engaged in a legal dispute with Texas Attorney General Ken Paxton, whose office recently targeted the homes of several LULAC members, seizing their phones and laptops under allegations of voter fraud. LULAC has denied any wrongdoing and has requested an investigation by the Justice Department into potential civil rights violations by Texas. Kathleen Joseph Bush, an analyst at the Migration Policy Institute, noted that state lawsuits challenging federal immigration policies have been another method by which states have reshaped immigration policy. These legal actions have stalled or blocked several federal immigration initiatives, including a program intended to grant legal status to some undocumented immigrants married to U.S. citizens. Joseph Bush emphasized that the outdated nature of the U.S. immigration system, which has not been comprehensively updated since the 1980s and 1990s, contributes to the difficulties faced by both federal and state governments in managing contemporary immigration challenges. As these legal battles unfold, the outcome will be pivotal in determining the future of federal immigration policies and the extent of state influence over immigration matters. The challenges faced by Republican-led states in proving financial harm, alongside the introduction of new procedural rules in Texas and a surge in state-level immigration restrictions, underscore the dynamic and contentious nature of immigration reform in the United States. How these cases are resolved will not only impact current immigration policies but also set precedents for future federal-state interactions in immigration law. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video.
Hello everyone, welcome back to channel US Immigration. We hope you're doing great. But in this video, we will talk about the appeals court ruling disappoints on Biden's parole program. Recent legal battles have emerged as Republican-led states challenge the Biden administration's immigration relief program, particularly focusing on financial harm claims. The Keeping Families Together initiative, which offers leave to spouses of US citizens, is one such program under scrutiny. Critics argue that administration's use of parole to admit immigrants imposes financial burdens on state economies. Last month, states secured a temporary freeze on the new parole-in-place program, but to overturn it, they must demonstrate concrete harm attributable to the policy. Recent Supreme Court rulings emphasize that states need substantive evidence of injury, not speculative claims. For example, GOP-led states previously challenged a parole program allowing up to 30,000 migrants monthly, arguing it increased public service costs. However, a district court dismissed this, noting a reduction in new migrants and financial burdens. This case is now on appeal, and the Biden administration contends that the states cannot show actual harm. In parallel, a new rule in the Northern District of Texas, effective September 3, delays transfers of civil cases outside the 5th Circuit for 21 days to address objections or agreements on transfers. This rule aims to combat judge shopping, a practice where litigants seek favorable rulings by filing in districts perceived as sympathetic. The rule responds to criticisms of the Northern District's handling of the case transfers and recent 5th Circuit interventions in high-profile cases. Additionally, state efforts to pass stricter immigration laws have been surged, with 2 anti-immigration bills introduced in the past year, up from previous years. These measures include criminalizing unauthorized entry and restricting sanctuary policies. Texas, a leader in this movement, recently enacted SB 4, allowing state-level actions against migrants. Though it is currently blocked by a federal judge, the League of United Latin American Citizens criticizes these laws, arguing they foster racial bias and counterproductive division. They advocate for comprehensive federal immigration reform. Meanwhile, state lawsuits challenging federal policies have further complicated immigration management, highlighting the need for updated federal immigration policies.